Charles L. Black Jr. once stated, "Though the justice of God may indeed ordain that some should die, the justice of man is altogether and always insignificant for saying who these may be." In my research, I will explore different death row cases. Also, I will examine the death penalty and if it's considered ethical. David Keaton was convicted in Florida in 1971. However, the charges were dismissed in 1973. David Keaton charges were on the basis of mistaken identity and forced confessions. Keaton was sentenced to death for murdering an off-duty deputy sheriff during a robbery. The state's Supreme Court reversed the conviction and granted Keaton a new trial because of newly discovered evidence. Charges were dropped and he was released after the actual killer was identified and convicted. It is human nature to look at capital punishment as being cruel. Nevertheless, many see punishment as deserving depending on the crime committed. However, the law contains real duties recognized by governments that are needed for maintaining social order and resolving disagreements, as well as for dispensing social resources according to what individuals deserve or need. Therefore, is it fair to associate capital punishment with being ethical or unethical? When killing a person and being ethical are obviously contradicting to one another. 20 states executed 98 prisoners in 1999, the most since 1951. The average death row stay was 11 years and 11 months. A North Carolina jury in 1975 acquitted Christopher Spicer of the murder of Donnie P. Christian. Spicer was convicted of a crime in September of 1973, but the conviction was overturned the following year by North Carolina Supreme Court. At Spicer's trial, the state offended the testimony of Charles Pemberton, a jailhouse snitch. Although the defense introduced two witnesses who testified that Pemberton and Spicer were never cellmates, Pemberton testified that Spicer admitted to crimes while he and Spicer shared a cell. After sharing the confession with policemen, Pemberton's bond was reduced from $5,000 to $400, and he was released from jail. Why wasn't ethics displayed in the trial? Pemberton was bribed to testify against a man for a lower bond. Maybe if being ethical was practiced early on, then the death penalty would have never been on the table. In overturning Spicer's conviction, the North Carolina Supreme Court held the trial judge committee reversible error by not allowing defense counsel to cross-examine Pemberton. To discover who the witness was indebted for such favors and certain to what extent to the favors colored his testimony against Spicer. Defense counsel were unable to question Pemberton as to who was paying the living expenses of Pemberton and his wife, neither who were working at the time. The court found that the trial court committed reversible error when it succeeded in presuming the defendant and his counselor into withdrawing the request for an appropriate instruction with regards to how the jury should scrutinize the testimony of other witnesses for state. At Spicer's retrial, the jury took only 15 minutes to unanimously acquit him. There were many ethical violations that took place in this trial. The case is one that had a great ending. However, how many cases have slipped under the fine-tooth comb and the person was put to death? This by no means could be ethical. Next, Delbert Tibbs, of Florida, was convicted in 1974. However, charges were dismissed in 1977. Tibbs was sentenced to death for rape of a 16-year-old girl and the murder of her companion. Tibbs, a black student, was convicted by an all-white jury on the testimony of the female victim, who testified was inconsistent with her first description of the assailant. The conviction was overturned by Florida Supreme Court because the verdict was not supported by the weight of the evidence, and the state decided not to retry the case. Tibbs' former prosecution said that the original investigation had been tainted from the beginning, that if it was retried, he would appear as a witness for Tibbs. To uphold the law has a present of ethical duty within itself. Also, one of an attorney many duties is not to encourage either the beginning or the extension of the action of the proceeding from any corrupt motives of passion or interest. Being ethical has to start from the beginning. The charges that are being administered and the trustworthiness of the witnesses. In almost every state, the judicial has adopted an ethical code based on the moral rule of professional conduct to govern lawyers' work. I honestly believe that the ethical code should be adopted when it comes to the punishment phase. Lastly, an Arkansas trial judge dismissed all charges against former death row prisoner Ricky Dale Newman on October 11, 2017, after nearly 16 years in prison for the February 2001 murder of a woman who lived in the outskirts of Van Buren, Arkansas. A former Marine with a major depression, chronic illness, stress disorder from childhood abuse, and an IQ in the intellectual disabled range. Newman was seriously mentally ill and homeless at the time he was charged with the murder. After falsely confessing in an interrogation, the court found him competent to stand trial and to represent himself. He was convicted and sentenced to death in June 2002 after a one-day trial in which Newman told the jury he had committed the murder and asked them to impose the death penalty. With no physical evidence linked Newman to the murder, of the DNA evidence of the blanket of which the victim was found excluded Newman, but a prosecution expert falsely testified that the hair found on Newman's clothes had come from the victim. Newman subsequently sought to waive his appeal and be executed. However, 4 days before his scheduled execution, July 26, 2005, Newman permitted federal public defenders to seek a stay of execution, and the lawyer obtained DNA testing of the hair evidence that disproved the prosecution's trial testimony. They also discovered the prosecution had withheld from the defense evidence from the number since the contradicted what Newman had described in the confession. A federal court hearing also provided evidence that the state mental health doctor had made significant errors in administering and scoring tests he had relied upon in testifying that Newman had been competent in the standard trial. The Arkansas Supreme Court subsequently ordered new hearing on Newman and on the evidence that the prosecution had withheld from the defense. Along those hearings, it wrote that the record overwhelmingly illustrated that Newman had mental illness interfered with the ability to effectively and for him to stand as his own counselor, and overturned his conviction. In 2017, it issued another ruling bearing that using Newman's incompetent confession in a retrial. The prosecution then asked for the charges to be dismissed, noting that without the false confession, prosecutors lacked significant evidence to obtain the conviction, and it would be a waste of taxpayer money to retry. One of the chief values of standards of setting has been to reframe the death penalty as a human rights issue. Forensics psychologists, those who specify in training and evaluating treatment and relevance to legal proceedings, have been increasingly involved in the death penalty case since the Supreme Court ruled in Gregg versus Georgia in 1976. The capital sentencing must be tailored to the individual offense and the person who commits it. In practice, there has meant that during the sentencing phase of capital case, court must consider psychology factors that might influence a jury recommendation for execution or life imprisonment, such as whether the defendant is capable of understanding the state's reasons of execution or is likely to engage in further violence and behavior. In all cases that has been present, human rights were violated in some form or fashion. Being truthful and accountable for what was being presented was somehow thrown out the window. This is wrong, and people that are presenting these cases should be liable for information that presents and punished if their information is corrupt. Convicted and punished if their information is corrupt or tainted for winning purposes. The death penalty question is often framed in practical terms of net balance, right of victim versus right of life of the convicted. However, it is not that simple. One right should not to determine life or death for a person, regardless of the crime. Most of the time, people want a quick place blame on something terrible that has happened to them or to someone that they love, never thinking if there's a possibility that there may be wrong. Regardless of any statistic, the death penalty is not ethical.